Good afternoon, everyone. Welcome to the first part of our two-part webinar series, which will discuss significant construction and adjudication cases of 2019. These webinars will cover key developments in construction and adjudication practice and how these might affect your construction project disputes in 2020. This first webinar will focus on our chosen top 5 construction cases of 2019, and we will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. Now, if you'd like to ask a question, please do so by using the Ask a Question tab. In order to keep within time, we will be answering as many questions as we can at the end of the presentation rather than as we go along. Now, if we don't manage to get to your question, or if you are listening to a recording of this webinar, we would be happy to address any queries after the webinar by phone or email, and our contact details are noted on the next slide. So, your speakers today, I am Iain Drummond, a partner specialising in construction and engineering dispute resolution. I'm joined by my colleague Fiona Kennedy, who also deals with contentious construction. Our team regularly advises on construction contract issues and disputes across a range of projects and clients, and we therefore have a great deal of experience in litigation, arbitration and adjudication, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. I'll now pass you over to Fiona, who will run through the agenda for today's webinar.
Thanks, Iain. We will start today by looking at the case of Mayors Limited against Cost-Plan Services South East Limited and others, the first piece of guidance given by the courts on the meaning of practical completion in over 50 years. We will then discuss Loreto Housing Association against Cruden Building and Renewals and another, which considers the current state of the law of prescription, also known as time bar, in Scotland, and in particular the point from when the prescriptive period should run. Next will be British Overseas Bank Nominees Limited against Stuart Milne Group Limited, which considered the interaction of prescription and collateral warranties. We will then discuss Flexidig Limited against A. Coupland Surfacing Limited, which considers a subcontractor's right to remedy defects during the defects liability period. And finally, we will look at M. Davenport Builders Limited against Greer and the concepts of smash and grab and true value adjudication. These cases are a mixture from the Scottish and English courts. Much of Scots and English contract law and many of the standard form contracts used for construction projects are common across the border. The English courts have a larger number of disputes and appeals than the Scottish courts, and therefore key lessons can be learned from looking at English cases. These cases are very often persuasive in Scottish actions and vice versa.
So, we begin with the English case of Mayors Limited against Cost-Plan Services South East Limited and others, in which the Court of Appeal provided some useful guidance on the meaning of practical completion. As many of you will be aware, this term is rarely defined in construction contracts and has been said to be easier to recognise than to define. In this case, Mayors, a provider of student housing, entered into an agreement for lease for a 21-year lease of 2 blocks of student accommodation. Cost-Plan was appointed as the agent of the employer. Under the agreement for lease, the lease became complete within 5 days of the blocks achieving practical completion. The lease could also be terminated if practical completion was delayed. As matters fell out, works were significantly delayed and there were various defects in the accommodation blocks. One of these defects was that some of the rooms were built over 3% smaller than had been stipulated in the agreement for lease, and this was in contravention of the maximum tolerance range stated in the agreement. So Mayors sought a declaration in court that practical completion could not be achieved because these defects contravened the agreement and were material and substantial. The court at first instance disagreed and held that this failure was not a sufficiently material or substantial breach of the agreement, and therefore could not prevent practical completion occurring. The court stated that patent defects can prevent practical completion occurring. However, it said that this was dependent on the nature, extent, and consequence of the defects. The appeal court agreed with this view and provided some additional helpful guidance on practical completion in general. Firstly, practical completion is itself difficult to define, and there are no hard and fast rules. Secondly, latent defects, that's hidden defects, cannot prevent practical completion, as by their very nature they are unknown. Conversely, patent defects, which are defects that can be seen, patent defects can prevent practical completion so long as they are not trifling in nature, extent, or effect. And in assessing whether a defect is trifling or not, the ability to use the works as intended may be a factor. For example, in this case, the fact that the rooms were 3% smaller did not prevent them from being used as student accommodation. Thirdly, items of work that remain outstanding and those that are completed but require rectification are to be treated in the same manner when considering practical completion. And lastly, the mere fact that a defect cannot be remedied, as was the case in this scenario, does not mean the works are not practically complete. The question remains whether the defect is trifling. So, what can we take away from this decision? Well, a patent defect may well prevent practical completion in the same manner as incomplete work. However, practical completion will very much be judged on the factual circumstances of each case and is dependent on the nature, extent, and consequence of the defect. The key test which parties should keep in mind is whether the defect is merely trifling or sufficiently material to prevent practical completion, and in assessing this, whether the works are in a usable state may be taken as one of the indicators. Fiona will now move on to our next case, which considers the law of prescription.
Thanks, Iain. Many of you will know that prescription is currently quite an uncertain area of Scots law. Following a significant change in 2014, when David T. Morrison against ICL Plastics case turned decades of common practice on its head by deciding that there was no need for knowledge that your loss had been caused by someone for the prescriptive clock to start running. As a brief reminder, in Scots law, many obligations prescribe, i.e. time runs out, after a period of 5 years, including obligations arising from liability to make reparation for loss, injury, or damage. Under Section 11.3 of the Prescription and Limitations Scotland Act, 1973, the 5-year period does not begin until the party who has suffered loss is aware, or could with reasonable diligence be aware, that the loss, injury, or damage had occurred. We covered a case in our June webinar last year, Midlothian Council, which changed our understanding of the law of prescription even further, as it held that knowledge of incurring of expenditure was sufficient to mean that the pursuer had knowledge of suffering a loss, even if, in reality, the loss sufferer did not know that they had suffered a loss. For example, by paying a contractor to start building to defective designs, even though they did not know that the designs were defective until later. Our next case today is a Scottish decision from the Court of Session, Loretto Housing Association against Cruding Building and Renewals and another, which tests the Midlothian Council decision. This case was due to go to a full proof, also known as a hearing, but the defenders raised prescription as a preliminary argument, which was the subject of a debate. Loretto was heard by the same judge, Lord Docherty, who decided Midlothian Council. Loretto engaged Cruden to carry out the redevelopment of a Glasgow's Duke Street Hospital into residential flats and a day centre, and the works were practically complete in 2000. There were various other parties involved, Cameron Ross as structural engineers, Cooper Cromer as architects, and John Arnott Associates as clerk of the works. In 2013 and 2014, over 10 years on from practical completion, Loreto obtained reports on the condition of the building from third-party engineers, which revealed several significant defects, for example, that the roof had been installed defectively. In 2015, Loreto raised an action against both Cruden, the contractor, and Cameron Ross, the structural engineer. In turn, Cruden sought contributions from the architect and clerk of the work due to their alleged failure to inspect and supervise Cruden's work. The two defenders argued, as per Midlothian Council, that Loreto's claim had prescribed, as payment was made more than 5 years before proceedings were raised. Loreto, boldly as it was in front of Lord Docherty himself, argued that Midlothian Council had been wrongly decided, as the pursuer could not with reasonable diligence been aware that it suffered loss, injury or damage until the latent defects were identified. Loreto further argued that the facts in this case could be distinguished from that of Midlothian Council. They advanced an argument under Section 6.4 of the Prescription and Limitation Scotland Act 1973 that they had been induced to refrain from raising proceedings by the defenders. The effect of making this argument successfully would be that the prescriptive period would be paused, and the basis for this argument was that the engineer had failed in their inspecting and supervising role, leading to the architect not being advised of the defects and certificates then being issued erroneously. Consequently, Loreto had no reason to suspect that the work certified had not been carried out to the required standards. The judge was content that the submissions at debate were sufficient to merit a further hearing, leaving the possibility that, on the facts of this case at least, the prescriptive period may have been paused due to the ongoing advice and role of the professional team. Keep an eye out for future developments in this case. We are also expecting an appeal in Midlothian Council, which will hopefully provide further clarity. There are a number of lessons we can take away from this case. The first is that although the reasoning in Midlothian Council is not quickly being discarded, each case will be looked at in its own circumstances, and there may be reasons why the Midlothian Council doctrine might not apply. In the construction industry, it can often take a significant length of time for defects to become evident, and so when considering whether to raise an action, prescription must be one of the foremost considerations. Parties should keep in mind that prescription is fatal, i.e. it has the potential to effectively knock out the entirety of your claim. We would therefore urge potential claimants to err on the side of caution for the time being and be conservative in calculating the likely date for the prescriptive period to run from. The introduction of the Prescription Scotland Act 2018 may help to clarify this issue. However, as yet, we don't know when this will come into force.
Our third case, British Overseas Bank Nominees Limited against Stuart Milne Group Limited, follows neatly on from Fiona's discussion of prescription. Many of you may have heard of this case, which caused waves in the construction industry in late 2018, when the Court of Session in Edinburgh held that British Overseas Bank were able to pursue Stuart Milne despite practical completion occurring on the works some 9 years before and defects arising more than 5 years prior to the action. Stuart Milne had designed and built a retail park in Inverurie, Aberdeenshire, which was completed in 2009. In June 2013, the site was acquired by British Overseas Bank, who obtained collateral warranties from Stuart Milne, the contractor. The site car park had been subject to flooding, which was documented in a report in May 2013. But it wasn't until 21st of June 2018 that the claimant, the pursuer, raised an action for breach of the 2013 collateral warranty in relation to this flooding. Stuart Milne argued that the opportunity for parties to bring proceedings prescribed in May 2018, which was 5 years after the reported flooding. However, British Overseas Bank argued that Stuart Milne's liability under the collateral warranty was independent of its liability under the building contract, and that the prescriptive period, the time bar period that is, should run from the date that Stuart Milne executed its collateral warranty. This was despite the collateral warranty containing a no greater liability clause. At first instance, the Court of Session decided that the granting of the collateral warranty did create a new 5-year prescriptive period, and that if Stuart Milne intended for rights under its collateral warranty to be limited as proposed, then that would need to have been set out clearly in the collateral warranty. However, to the relief of those in the construction industry, on appeal, the Court of Session focused on the purpose and function of the collateral warranty, which is to give the purchaser rights against the contractor which are equivalent to those of the employer under the building contract. Therefore, the court reversed the first instance decision and decided that the collateral warranty had no different prescriptive period than the building contract. So ultimately, this means that the status quo has been reinstated, and the traditional understanding that collateral warranties operate alongside building contracts in an auxiliary rather than independent manner continues to be the position. In the future, parties should note that the prescriptive period under a collateral warranty with a no greater liability clause will therefore be the same as that under the underlying building contract. So the granting of a collateral warranty sometime later does not create a fresh 5-year prescriptive period.
Now on to our penultimate case today, which is Flexidig Limited against A. Coupland Surfacing Limited. Flexidig was engaged as a subcontractor by M&M Contractors Europe Limited on a civil engineering project under M&M's standard terms. This included a defects liability provision, placing an obligation on Flexidig to remedy defects for a period of 2 years following completion. If this was not complied with, the clause provided for an alternative contractor to carry out the works at the expense of Flexidig. Many of you will be familiar with this type of clause as it is common in construction contracts. Defects in Flexidig's works were discovered and an adjudication followed in which M&M was successful. Enforcement of the adjudicator's decision was stayed, i.e. paused, to allow Flexidig to return to site to make good the defects. M&M, however, were not satisfied with the standard of Flexidig's works and engaged a second subcontractor, Coupland, to carry out the works. Flexidig argued that it had a contractual right to return to site and remedy any defects during the defects liability period. It unusually applied for an injunction to prevent Coupland from carrying out the works, and this was on the basis of procuring a breach of contract. This application was swiftly rejected. The judge noted that there had been no inducement by Coupland, as facilitating was not the same as inducing. Additionally, Flexidig had been removed before the involvement of Coupland. He further noted that although it was arguable that there had been a breach of contract resultant from the failure to allow Flexidig to carry out the remedial work itself, the defects liability clause did not expressly prevent M&M from engaging a second contractor. Although it was implicit in the clause that the contractor must request that the subcontractor remedy defects if it subsequently wishes to claim costs of engaging a second subcontractor, the judge did not think that this meant the subcontractor should be offered the opportunity to do so in all cases. Furthermore, the judge did not think that an injunction was appropriate. Rather, the defects liability provision sets out a mechanism for the recovery of damages. In this manner, Flexidig could seek to avoid any added cost of a second subcontractor carrying out the remedial works in any claim from the contractor. This follows the conventional wisdom. An employer has the right to employ a second contractor to carry out the remedial works and seek compensation from the original contractor. However, the employer cannot recover costs greater than the hypothetical cost of the original contractor carrying out the remedial works itself. It is therefore critical that good relationships are sustained, as it will often be more expensive for both parties if alternative contractors have to be engaged. I'll now pass you over to Iain to discuss our final case today.
Okay, many of you will be aware of a significant case from 2018 which we featured in last year's webinar, and that's Grove Developments Limited against S&T UK Limited. This case continued the debate on cross-adjudicating on the true value of the works in response to a so-called smash and grab adjudication, which some have speculated could mark the end of smash and grab adjudications. As a reminder, a smash and grab adjudication is where 1. The contractor has applied for payment, usually in its interim application. 2. The contract administrator and employer fails to issue a valid payment notice or pay less notice. 3. The contractor's application for payment therefore becomes the default payment notice, which fixes the amount due from the employer to the contractor. And 4. The contractor can then commence an adjudication to enforce payment of the sum set out in their application for payment, whether that sum is inflated or not, and without the merits of the sum being considered. The courts have showed themselves reluctant to interfere with the statutory payment regime, even where it does lead to payments which are higher than the true value of the works carried out. Now, in Grove, the Technology and Construction Court held that on payment, Grove was entitled to pursue a further adjudication following the smash and grab adjudication to determine the true value of the works. The Court of Appeal followed the decision of the TCC and dismissed the appeal by S&T and found that Grove was entitled to bring essentially a counter adjudication. This marked an important development in smash and grab adjudications, as it was held that even in the absence of a valid payment or pay less notice, the payer can raise a counter adjudication on an interim payment application, but importantly, as said in Grove, only after the windfall smash and grab payment had been made. Now, our final case today, M. Davenport Builders Limited against Greer, confirms this position. Davenport and Mr. and Mrs. Greer were in dispute over the payment application for the final account, and the contract in their case made no provision for adjudication or payment, and so the construction scheme was implied into the contract. The Greers failed to submit a payment notice or pay less notice within the required timescales, and so Davenport issued a payee's default notice adjusting the final date for payment. The Greers failed to pay, and Davenport commenced adjudication. Davenport was therefore awarded the full amount claimed in its final account application plus interest. However, the Greers did not pay and instead commenced a second adjudication challenging the value of the final account. So effectively they wished to counterclaim against the amount awarded in the first adjudication on a smash and grab basis. However, in the second adjudication, the adjudicator decided that as a result of the re-evaluation, there was in fact no sum due to Davenport. Davenport then commenced enforcement proceedings to enforce the first adjudication decision, and the Greers, on their part, sought to rely on the decision in the second adjudication to resist payment. So the critical issue for the court, as it was in the Grove Development case, was whether it was valid for the Greers to rely on the second adjudication decision, considering they had not yet paid the amount awarded in the first adjudication decision. In the court, Mr. Justice Stuart Smith agreed with the reasoning in Grove Developments and held that before the Greers could rely on the decision in the second adjudication, they had to discharge their immediate payment obligation from the first adjudication. However, he did state that there may be circumstances where this principle does not apply, but he did not provide any further guidance on those circumstances or criteria. He further clarified helpfully that Grove Developments, in his view, applied both to an interim application for payment and to a final account, which was the circumstances in this case. So this case further establishes the important principle in Grove that payment under a smash and grab adjudication must be made before the employer can raise proceedings as to the true value of the account. However, Once that payment is made, the employer can commence adjudication immediately. So although Mr. Justice Stuart Smith does use other authorities to suggest that this principle may not apply in all circumstances, he did not explain that further. So we may have some development of that point in future cases. So that's the last case we'll be discussing today. Fiona will now highlight the key takeaway points from each decision.
So firstly, in relation to practical completion, the courts are hesitant to attempt to define such a complex term. However, we now understand the key test is whether defects are trifling in nature. Secondly, as reported in a webinar last year, prescription in relation to construction contracts remain in a state of flux. Currently, we urge any future claimants to be conservative when considering from which point the prescription clock begins ticking. Thirdly, British Overseas Bank cemented our traditional understanding of collateral warranties in that they are accessories to contracts and do not themselves begin a discrete prescriptive period. Fourthly, Flexidig suggests that although it may be a breach of contract for employers to prevent a contractor from remedying defects during a defects liability period, the provision itself does not prohibit an employer from engaging a second contractor. Employers should, however, be mindful of the additional costs that may be incurred as a result of denying the original contractor to carry out rectification works itself. And lastly, the Grove decision has been reinforced, and payments in a smash and grab adjudication must be made before a true valuation adjudication can be raised.
Thank you, Fiona. So we've now come to the end of this webinar, which we hope you found useful. And we still have a minute or two to answer questions. So if you haven't already done so, please type your questions into the chat box now. And while you're doing that, I will take the opportunity to remind you that the next webinar in this series of 2 will take place on Tuesday, the 18th of February. And that will be a roundup of our chosen top 5 adjudication cases of 2019. And we'll again consider the factual background, legal points and lessons to be learned from each case. So if you haven't signed up for that one already, then please do so by visiting the events section of our website. And just as a reminder, this webinar has been recorded and will be available on our website shortly, and we will circulate details of the recording to all participants after the webinar. So we have a question in relation to the new Prescription Limitation Act 2018 as to when it's likely to come into force. The truthful answer is we don't know yet. There's limited information about that. Apparently the delay, despite it being put on the statute books about a year and a half ago, the delay in bringing it into force in Scotland is due to consideration being given as to whether or not it should have retrospective effect when it's brought into force. There's a lot of competing arguments about that, and it's quite difficult, I think, to find the right answer. It's a real problem for Scots law at the moment, because the way the case law has developed over the last few years, we're really in a position now where if you have a case involving latent defects and you're a claimant, you may well find that the prescriptive period, the time bar period in Scotland, has actually ended by the time the latent defect becomes apparent. Now, that was certainly not the intention of the 1973 Act, but unfortunately, that's the way it's been interpreted in the last few years. So it is a big problem, and that's why consideration is being given to the new legislation having retrospective effect. But you could, of course, imagine the difficulties that will create with existing cases. So we're really not sure, but I think all of us in practice are hoping it comes into force soon, because it will provide some much needed clarity around that bit of the law in Scotland. And certainly, you know, we'd encourage all claimants, really, when looking at latent defects claims, really the first thing you should be considering is the potential for the claim being time barred. Okay, so there is another question or two on the screen, but that's us out of time now, so we will respond to the people who've asked those questions by email or by telephone. So thanks very much again for listening, and we hope you found this webinar useful, and we'll look forward to welcoming you to our next webinar in February, where, as I said, we'll be discussing last year's noteworthy adjudication cases. So thank you.